Welcome everybody, including those visiting by recording. Um, State up front that there are no attendance points. There's no live class points. Um, there are certainly points available both in doing the slideshow that you create and in doing the quiz because most of my students have not recently done quizzes. A bunch of my students now are certificate students, but that doesn't necessarily mean that they got a college degree last year. They may be in the same boat as my um, associate students of not being in school for a while, being out there in the working world. The advantage of being in the working world is I don't have to coach you a lot on managing yourself, self-discipline, all of that stuff. You have it. You're already um, almost all my students are successful in some way in terms of helping others, um, taking care of kids, taking care of elderly parents. Your work life, you've stuck with it. You just want to do more. You want to do something a little different. Um, Maybe you see it as a little higher calling being a paralegal than what you do now, or maybe it's just a sideways change. That's up to you. I mean, I've had students that were managers or used to be successful in government work, and paralegal is not a step up financially, but it's a step up for them in terms of what they want to do. Um, and of course, I worked as an attorney for many years. Um, some of the stuff that I did definitely helps with teaching legal ethics because the same type of diligence standards, um, honesty standards work for avoiding malpractice and keeping costs low as they do for avoiding nasty letters from the professional board and the Supreme Court of the state. So if you do things right, it helps a lot. If you hire good employees, it helps. And you can be one of those employees that help. Um, it's much easier to meet the diligence standards, to meet the confidentiality standards, and so on when all of your employees are totally on board. And of course, your higher level employees, your paralegals, when they understand the score, how to win in the right way, how to treat clients with great respect, and also with helping the clients to safeguard their confidentiality. Um, that helps. And of course, that's what I kind of look like now, but the snow is gone, although it's supposed to arrive again tomorrow, but I think it'll melt right away. Right now, I'm so happy that the power came back on. The power was off for a couple hours and it's back on. So I'm broadcasting. It's nice. The furnace is back on because it's going to be in the 20s tonight. That's very nice. Um, the duty of confidentiality. Um, Sometimes we think of confidentiality as being without exceptions, and that's not quite true. There are some narrow exceptions, but the exceptions are come up so rarely that in terms of taking it out past the people that are helping, um, you know, people that are full-time or temporary part-time employees do get to know some confidential information, but they are sworn to silence just like the lawyer is. Questions about that. In other words, if you work for a lawyer either temporarily or permanently, you are also required to be super confidential. Even if it would benefit a friend or a family member, you're not allowed to make use of what was said. Questions, comments about that? It really helps. Uh, it helps to think about this. Um, welcome, by the way. I now I have two Shannons, Shannon Pinnock, Shannon Preet, Zaria, and Chandler Ryan, all here. Um, we're just trying to get to the basics of confidentiality now and think about it. Um, Paralegals can help not only meet confidentiality rules in terms of avoiding ethical problems, but also being so ethical that you're also diligent and avoid malpractice, and also um, on the positive end, um, being very ethical and diligent with the clients helps the law firm, and what helps the law firm eventually does help the paralegals that work for the law firm as well as the attorneys. A successful law firm, people go to it not because they're mean and nasty and are going to necessarily deliberately lie, cheat, and steal from the bad guys on the other side. That's not really workable in our system. Some folks think it is. One guy came to me and he said, "Would you like to be a junkyard dog for me?" And I was thinking of a junkyard dog, maybe some dog that was had to be kept normally behind barbed wire because the dog is so dangerous. Some dog maybe slathering and wanting to bite, and I didn't like identifying as a junkyard dog. How would you folks like being asked to be a junkyard dog? Would you like that image? Yeah. And I understand the idea of it's an extremely hyper-competitive profession. I understand that, but I'm not willing to step into any possible role that the client would give. But you will never get it out of me who asked me that, okay? Why would I never say who asked me to be a junkyard dog? Why wouldn't I tell? It would be more fun for you if I could say the person's name. Why am I so closed-mouthed about stuff like that?
Because it's confidential.
Correct. Absolutely correct. Um, Even the dumb stuff that you would think doesn't matter, it is confidential. Um, One of the additions to it is we can't even make use of confidential information um, for our benefit or family members' benefit, even if it wouldn't hurt the client. Let's say the client has no interest in buying houses, but the client whispers, "Oh, hey, I'm thinking of bringing a new manufacturing plant into your town, and that will create a housing shortage. I'm afraid it will. Can I get my kids to buy houses in that area that we can rent out? Can I do that? What do you think? Doesn't hurt the client. No, you absolutely, yeah, you can't actually do that. You cannot make use of, um, how about a paralegal that finds out about it? A paralegal is not an attorney, of course. Can they do that? Can they say, well, um, I'm going to get an option or a purchase agreement on a couple houses in that area, and then if it goes through, then I'll snap those up for a low price and resell them high or rent them out.
No, because it's
Can a
a
par
no, because it's like a client relationship sort of. You can't do that, correct?
Yeah, and that is correct. You are correct. But it's not clear necessarily from each state's actual hard black letter code that that's true. But I think in most states you're going to find court decisions that say you can't do that. Um, or you're going to find comments below the rules. In some cases, it may state that in the rule. But you would have to go through a lot of rigmarole to get permission from the client. And by the time you do that, it's almost not worth it. I would say, unless the client said, well, this is public information and so on, the problem, of course, the problem is that if you ever do that and it turns out that the fact that you're buying gives away the secret, um, then you could definitely see the purpose of it. But even if you're sure that it won't give away the secret, we can't really make use of it for profit, um, secrets for profit at all. Um, it's just super strict, but there are certain um, exceptions, and there are several of them. So you think, well, if there's several, then there's a lot of holes in it, but there really aren't because they're very narrow exceptions, hardly ever come up. Um, Now we're going to do a little bit of the fun part, and uh, I spent most of my career never being like a game show host, but I remember this from the movies, and I sort of feel like a game show host sometimes when you do quiz shows. You don't act like a scientist, you seem more like a game show host. Bill Murray, I suspect I maybe wouldn't like, she's talking about the Bill Murray character. I don't know if I'd like Bill Murray in real life, although I'd like to play golf with him sometime. He's a real goofball. He'll wear a funny hat and, get people to holler while he's hitting the ball and whatever. But um, anyway, probably wouldn't get along with him, but it's a funny thing. But um, so let's see how fast you can come up with this. Who else has authority to impose discipline? Oh, yeah, judge. Okay, you're right. A is definitely right. That's typical. Um, there are such a thing as mandatory bar associations. This voluntary can't actually impose discipline, but mandatory bar associations that are under each state's higher court. Basically, a mandatory bar association basically creates a professional responsibility structure anyway. So A and B are actually correct. Class versus instructor, answer in 5 seconds. Which has authority to regulate licensed attorney? The ABA, each state's top court, or the Federal Trade Commission? A, B, or C? Everybody take a shot at it. Even if you think you might be wrong, try, because it helps you do quizzes later. And here's how I would kind of puzzle it out. Well, here's how I would puzzle it out. I'd say ABA. Well, Mr. Olson kept bragging on the ABA as if he doesn't like them. Um, well, the fact that Mr. Olson doesn't like them is not necessarily a clue that they don't have any authority, but he was pretty clear that they don't have authority. So I'm going to cross that one off. So that leaves two. So we'll puzzle that out. And each state's top court, everything he said kept saying that one. But then Federal Trade Commission, I don't really know how they would regulate anything. If they do, it's some narrow exception I've never heard of. I'm just going to guess that that's not it. Okay, that's how I would look at it as a student. So I would choose B as the best answer. Plus, it doesn't say A and B or B and C, so I would go only with B. Okay. I'm just kind of coaching you on how to puzzle these out because logic does help. Um, they are open book too in terms of, I realize you don't have a text, but you have readings and you're allowed to use the readings as you go through. It does help though to sort of review the readings for the last couple weeks before you take the quiz, rather than to go in dry and hope to find it. Plus, a lot of times, I didn't do the quizzes, but a lot of times the quizzes are not so supposed to be super tricky, but they require logic precisely because they are open book. It's not pure rote memory. So if the reading says one thing in an exact form, the question will probably ask you the question in a different way. If the readings have something in the negative format, the question will probably ask you something in the positive and vice versa. Does that make sense? You imagine yourself coming up with quizzes. If you decided to quiz your kids at home, if you had grade school or high school kids, you would not necessarily always ask them the exact same question as was in the book, would you? Yeah. You try to get them to think about it a little bit because their memory would work a little better. And then, of course, you're also pushing their logic. So the same thing happens here. UPL in legal ethics is unable to practice law. That sounds right. So I put a question mark, unauthorized people's lives. That sounds too odd. So then I have to decide between these two. Um, Unable, and we just did not talk about unable in any of the stuff. So I'm gonna, as a sample student, I'm gonna guess that B is the answer. Who agrees? Okay, B, you agree. Um, thanks. Sometimes you have just known the answer, but if you do not deadly accurate, completely sure, know the answer, just puzzle it out as well as you can. And of course, again, you may skim through the readings, but if you don't have notes on the readings, they're extensive enough. It's hard to do that while taking it. It's hard to read them thoroughly while taking the quiz. Better to read them before taking the quiz and have your notes, kind of know where things are, which is not UPL. And of course, these you're saying, well, why are we talking UPL? Yes, it does include last week's reading. And here's a thought question because it's not obvious. You have to think about UPL as opposed to just having a memorized answer for this one. Um, this sounds bad. Paralegal yells at a client for failure to attend a court hearing. And for those that have never been a court clerk or a paralegal who had to work with difficult clients, maybe you wouldn't understand, be shocked at this if you worked in customer service and whatever. But some clients will not look out after their own welfare. And I guess I want you to have some compassion for people who lose a little patience with people. But this sounds bad, but is bad always going to be UPL? Is bad the same as UPL? If a person is emotionally, uh, see, so we have to look at practice of law. Yelling is not necessarily the practice of law, and failure to attend a court hearing. Let's assume the paralegal does not say, don't add in other words, don't use imagination, don't add in to A. You could say A is arguable because the paralegal could have been explaining the legal consequences of not attending. One problem with being a paralegal is you don't get to do that. So you may be tempted to yell at somebody instead and say, you said you'd be there. You have no excuse. I can't believe you're not there. What's the matter with you? And because you're not allowed to interpret the law to the client. You're not allowed to say, well, a bench warrant will most likely be issued by the judge, and when you're arrested, you'll serve at least 3 days before we can even get you out. Um, do you see where you cannot do that as a paralegal? But don't do that. Here's what's not to do. Do not add facts to a possible answer with your imagination, because then it would be impossible to do any quiz, any workable quiz. If you're allowed to add facts, quizzes won't work. So A doesn't work. If it doesn't work until you add facts, then cross it off, okay? Paralegal drafts, signs, and mails a letter of advice to a client after speaking on the phone to an attorney about it. If you read through fast, this one sounds arguable, doesn't it? But it doesn't say that the attorney signed it as well. So we cannot add facts and say, well, the attorney must have signed it too. No. So the paralegal cannot sign and mail a letter of advice to the client on their own, even if they do talk to the lawyer. And lawyer does a probate proceeding in the state in which a lawyer is not licensed without. Well, this is definitely UPL. Okay, now we have to read this carefully. Which is not UPL? Okay, which is not UPL? A is not UPL. Yelling is not UPL. Okay, so we figured out what was UPL, and A is not UPL. Okay. We decided this was not unauthorized practice. You really have to work, and I kind of sent you down a trail, not using I avoided analyzing not a little late in there, but you have to sometimes read and reread the question. Watch for double negatives. If there's a double negative in there, that will create a problem with answering a quiz correctly. Double negatives mean it. In legal language. See if I can come up with a question, okay? Okay, here's one that's a hidden double negative. Failed to stop. You really have to analyze these carefully. And here's one, I suppose a double negative doesn't matter that much in this one, but I want you to just think about double negatives and use them. Use them logically. And now analyze this one as a lawyer or paralegal, and as an ordinary person. We have to not go to court until it is close to the hearing time. What does that mean to an attorney thinker?
Well, you can't forge
We can go early.
anybody's signature, especially an attorney's,
Right,
right?
right. Yeah. Failed to stop is a double negative. And like I said, I didn't really set that up. So the double negative had to be analyzed exactly, but I want you to think about double negatives. And here's another one. We have to not go to court until it's close to the hearing time. What this means to an attorney is we can go early if we want to, or on time. Okay. What does this mean to an ordinary person? To most people,
Well, you're
not is an intensifier.
I guess you're trying to find another way in order to get the signature prior to.
No, the second, can you guys see the second line that I wrote? We have to not go to court, that one. Sometimes there's a delay when I type things on the whiteboard.
Okay, I'm sorry, I see it now.
Yeah. Um, not, not, double negative. A lawyer analyzes it logically. And when you add the other not, it makes it the opposite or almost the opposite, okay? Not going to court until it's close to the hearing time basically means go ahead and go early. So you have to analyze these things logically. Yeah, here's one. Stop avoiding taking personal injury cases. Not perfect English, I guess, flow, but if they stopped avoiding taking personal injury cases, would they take a personal injury case? Might they take one if they stop avoiding it? Yes. If you read through it fast, though, and didn't analyze it, you might think stop avoiding basically meant don't take any, okay? But lawyers use double negatives a lot, and people who create courses um, and well, uh, when you take quizzes, if you catch a double negative, analyze it logically. Don't take it for granted that it's an intensifier. If it's not like somebody calling on the phone and saying, "You absolutely have to um, stop getting home late." You know, um, no, that was a bad one because yeah, you have to stop getting home late. Stop. Oh, then you get to go home late. You know, lawyers are the wise guy. Lawyers when they were teenagers heard somebody saying that they have to stop getting home late. They took that as a license to get home late. Maybe that's a memorable one, especially those of you that are listening in person or have already had teenagers at home. Um, stop getting home late would give a future lawyer a license to stay out. Which can the lawyer reveal? And this one, these are both ones that have come up in real life, not in necessarily in my practice, but and this you have just puzzle it out, I guess. A lot of your confidentiality questions come up with where something is so extreme that even the right of confidentiality of the client has to yield. It has to be something very extreme. Shannon Pinnock says B, the statement of a client of how he plans to kill his boss. Not just that he's mad enough to possibly kill, oh, I could kill that guy. It's not just, oh, I'm so angry. You can't believe how angry I am. But somebody comes in and says, well, I bought a kit and I have some other stuff at home and I'm going to wire his car, a certain way. And, you know, um, they stopped this is not something I learned as an attorney, but I heard through the grapevine and found out later on. I was not the lawyer for the party involved, but a building that my wife worked in, a guy made a validly sounding terroristic threat on how he was going to blow up the building where my wife worked. And he actually had um, bomb making equipment. He had gathered it up on how he was going to terrorize and kill. Um, and so a future action um, a future action um, can be revealed, okay? A past action normally can't be. Um, B is correct that the lawyer can reveal that one. Price of house is a matter of public record, but the client said not to tell. This actually came up and couldn't tell. And the lawyer that couldn't tell got some people very angry that they had to go up and look it up at the courthouse. But that's too bad. If the client wanted to make it more difficult for somebody to know that they didn't want people snooping unless they're willing to like go to the courthouse or in today's world look at the courthouse website and puzzle through it, that's up to the client, not up to the lawyer to say, well, we're going to do a shortcut. Do you see how extreme that it has to be before confidentiality can be breached? Um, if a client comes in and says, I just killed my boss and here's how I did it, that has to be confidential. And that seems extreme, but um, ultimately there's a purpose for it. The lawyer may be able to convince the person to stand still, maybe even turn themselves in. Um, and certainly the lawyer will do the very best because he has a confidential relationship to stop the person from killing anybody else. And if there was no legal advice available that was confidential, people like that would do more harm. The fellow that was planning to uh, bomb the building that my wife worked in never bombed anybody's building, even though he was eventually released. And I suspect that legal advice had something to do with it. Legal advice that unhinged guy could trust. But if there was no client confidentiality that was very strong, I don't think he would have been willing to share any of his life with the lawyer. I don't know that he did. I don't have any idea what his lawyer eventually told him or anything. But I suspect that the lawyer talked him into some level of common sense. At least there was a chance that a lawyer could do that, and certainly whatever the lawyer did with him worked in his case because he never did anything serious and bad other than his big plan. Well, he did other bad and serious things before that, but not to any group of people he didn't know. He had done some bad stuff, but he stopped. Does this help you reconcile with how lawyers don't get to tell things, even bad things, unless it's like a future um, extreme crime felony? Does this help? Okay. This one's also kind of difficult when you haven't had a chance to look at the materials, but um, uh, intention of the client to change his plea to guilty, no, cannot reveal to the court. Technically, you also can't reveal a secret like this. What's the solution though? Um, if I was the lawyer, I would not be able to ask that client questions. So B is kind of a trick question because there is a penalty. The uh, excuse me. The answer is neither. But the problem with it is that in B, intention to lie means that he's going to have to testify in terms of what they call a narrative. Do you know what a narrative is? The attorney cannot ask questions. I did have that happen, and I just told the person that, I would have to just say, I'm going to call my client as a witness, and my client will just tell his story. And then the judge is going to know that the only reason I would not be asking questions is because I think that I know for sure that you're going to lie and not tell the truth. So I said, you're kind of messed up. You might as well either tell the truth or not testify, because there's no way I can hide that. And it's in some ways it's worse, because then the judge is going to think everything you say is a lie rather than the one thing. So basically, that lawyer needs to counsel the client not to testify or to uh, or to tell the whole truth, because unless the client intends to tell the whole truth, uh, it's going to come out to the judge anyway. Any questions about that? Comments, questions? Comments help. Think it through. It's really kind of weird. It comes up, but you can go years and years and never have it come up. Those exceptions. Who's going to come and tell somebody before they do something? Um, in the terroristic threats prosecution, it was people at a bar who called it in to the sheriff. It was not an attorney. Any questions about the intention to lie and how that's handled? The lawyer does not directly tell anybody. Microsoft Word encryption is not helpful at all for confidentiality, somewhat helpful or totally secure. In this one, you might not know the answer. Um, you can take a guess at it. Just take a guess if you don't know. Janet Pinnock took a guess at B. It is somewhat helpful. So not helpful at all is not correct. It's not totally secure, though. If you look it up on the web, you could find out that there's workaround. But it's somewhat helpful. Here's what it helps with. Let's say that uh, Attorney John receives an email not meant for him. Attachment is the confidential document. Okay. So John is not tempted to read it, is he? If he's not going to be if he's not intending to read confidential parts of it, he's not going to try to hack the document in order to make it work, because he already knows it's not meant for him. Does that make sense? Kind of similar to what we're talking about in the discussion. So he will notify the sender he deleted the communication, not try to read it, right? Okay. Um, So Microsoft Word encryption is not stupid and silly, but will it protect against a truly bad actor? You know, um, let's say that somebody does a reply all and it's a family law case or something. Uh, that could be really bad because it goes to not only attorney John, but it also goes to his client in a family law case. And the other side thinks that they're entitled to all this information. They assume that there are no real secrets. Well, this may be a true secret that the other party is not entitled to. But then they will try to hack it, and they maybe can. If they're techie at all, they can probably figure it out. So don't totally rely on Microsoft Word encryption, but don't make a joke out of it either. That's what I would look at. Okay. Courts and legislatures uh, both protect these people with rules against requiring testimony about legal confidences, secrets, and advice. Um, and again, you can argue with a question, but I don't want you to do that. You won't get points because you could say, well, lawyers are clients sometimes, and I understand that, but it's not saying that. So don't add facts with your imagination. Assume that lawyers are acting as lawyers. Um, when in doubt, use the regular basic interpretation of it that doesn't require you adding facts. Where overthinking really is adding facts with imagination. Um, Probably most people are not overanalyzing the actual question. They're adding stuff. They're adding stuff that's not there. Okay. So who is protected, do you think, from the confidentiality part? The lawyer for the client or just the client? What do you think? An instinct might be to say that it's lawyers, but remember that the Lawyer Professional Responsibility Code of each state does not protect attorneys. It does not, no, does not protect attorneys, just clients. If you want to protect attorneys, you'll have to come up with a confidentiality clause in an agreement. An example might be where the attorney has some special um, is selling something other than just legal advice, I suppose. Um, it would probably have to be an attorney who's also has some other role other than attorney. Okay, but um, I give golden advice that includes both business wisdom and legal advice to a client. I want the part, I want the business part kept confidential so that he can't sell it to other people. It's questionable whether I can even do that since I'm acting as a lawyer. That would be a difficult, I would probably have to call the professional responsibility director and find out if I could even do this. But I would, if I wanted to do that, I would call professional responsibility director and talk to a staff person and get some advice from them or another attorney. And if allowed by my state, I would make a separate agreement. Um, I would have to come up with some special agreement because, and that's outside the scope of what we're really doing here. Um, since that was not included in the question, that does not matter. It's just clients. All of the normal things. So if I say absolutely do not sign that contract. Um, do not sign that standard contract when your house is being renovated, because you have you know that a mechanic's lien will be filed, and so on. And I give some very particular advice to somebody not to sign an agreement with this contractor because I don't like the standard form they use. Um, then that client tells his friend, "Well, Mr. Olson says this and so," and then the friend then uses my advice for free. I am not protected. Do you see where I'm coming from? I have no protection as an attorney, none at all. I don't get to make another fee from the guy's friend, even though the friend may misuse the advice and use it uh, regarding a contractor form that is different. Um, so it's kind of frustrating because, when you give good advice that's very particular for one client, they will tell friends and family who will then use it to their own detriment. You know, that's one reason why it pays for both lawyers and paralegals. Do what you can with the lawyer to try to get it put into writing so that the lawyer's exact advice is in writing. And it should say in the letter that this is based on these facts, and that it may not apply to other situations. Okay? Do you see where I'm coming from? Because in some ways it does kind of cheat lawyers to have people uh, retail their advice letters to somebody else, or certainly their verbal advice. Um, you know, one time um, I gave an advice years ago. A guy came in, respected business person, but I trusted him, and I let him go out with verbal advice because I knew he would use it correctly. And my advice was 6% with no agreement, 8%. This was just an interest rate with an agreement in writing. And then I gave him the citation of statutes used. Okay. Um, so the answer was very simple, but he was very happy to pay for it. But instead of, this client was a good client, and he didn't just give it to everybody. Because why? He was smart enough to know that these answers were not for everybody. Um, Somebody else with a license to land, somebody with a real estate loan, private loan, or a bank, or a credit card company, all different answers. But I didn't have to do an elaborate agreement with this person because I could trust him. But basically, whatever I told him, he could tell anybody he wanted. I couldn't tell who came in and wanted to know the 6%, 8% answer, but he could say it to anybody. Does that make sense now? He could tell everybody in his neighborhood. It's kind of annoying because, some lawyers and some people who aren't even lawyers will meet at a bar. And one guy comes to me, came right from the bar, and he says, they can never convict me of DWI if I don't have a test, right? And I'm thinking, I said, well, why don't you go back to the bar? I said, you can get everybody to holler darn right. But I says, I don't pay, I don't get paid for that. I'm not going to scream darn right at you and then charge you $60 or whatever. Uh, I need to know the facts, and then I will give you some very particular advice that applies to only you, you know. And eventually, of course, I could do him some good, but you know, um, you have to be clear. The only purpose of the confidentiality rules that we're talking about is the clients. That's the only people who benefit. If a lawyer wants something confidential, they're going to have to do a few backflips and probably talk to the to the professional responsibility, one of the um, staff people. And, you know, you have to be careful, lawyers have to be careful doing business with clients other than just legal. And I understand, um, but in some cases, of course, the many cases there are other considerations, but usually the lawyer only makes money out of the legal part of it, not out of the business part of it or the general advice part. Um, there's certainly situations though where I talk people out of things, even though what they wanted to do was not illegal, it was just impractical. Or it was not illegal, but it was uh, liable to cause problems with the family or with friendships, business associates. It was liable to cause personal or moral problems or something for the individual. I can certainly talk to him about that or her and find out whether it violates his or her own code. Everybody has some kind of a moral code, and if it violates the client's own code, it's going to do them harm, even if they find out that it's legal in our state, whatever it is. Um, Sources to use. We want to talk about which sources to use. And there is an advantage of Lexis as a research system. It's not a database, it's a cross-reference system. I'm going to, the original purpose of the attorney-client privilege is not this. It's not to help guilty people run free. It's because people who can consult a lawyer with confidence will learn to comply with its laws. And like I say, a startling example was the fellow that I thought would be in prison a long time, but apparently he got some help. And I suspect that a lawyer assisted with that because the lawyer could be trusted, but I don't know who represented him. It wasn't me. I was against him actually, in some other matter. Um, Attorney-client privilege is what happens with confidentiality when you go to court, Heather. And the client can say, can ask the lawyer to go ahead and testify, and they can waive the privilege, or they can have waived the privilege by the way in which they um, handle things. They start to testify and they can lose it, or um, they can never have really had the privilege because they talk to the lawyer in the presence of other people. They should talk to the lawyer one-on-one. Um, Pick a state and go to rules of court. We're going to do that. Drill down using the tables of contents. Thoroughness, seeing related laws. It's slow at first, but it'll speed later searches and learn the structure and the headings. So can we go to Florida? So you go to Lexis, go to statutes and legislation, go to Florida local, state, and federal court rules, and then rules regulating the Florida bar. Okay. I'm going to do that live. Okay. Okay. We're going to scroll up, and we're going to start over on Lexus, and we're going to go to Florida. Okay, and if I go too slow or too fast, if your computer doesn't catch up, let me know. Then I'm going to go past cases down to statutes and legislation. Then I'm going to go to FL, Florida local, state, and federal court rules. And rules regulating the Florida bar is about halfway down, not quite halfway down. Um, it's way above the circuits, but it's way below civil procedure. And we want Chapter 4 rules of professional conduct right now. Later on, you can talk about rules of discipline, how it's handled. Rules of professional conduct. And then 1.6 is confidentiality. Rule 4-1.6. And it gives 5 exceptions on when lawyers may reveal and must reveal. Prevent a client from committing a crime or prevent a death or substantial bodily harm. Okay. And the advantage of being in Lexis, you scroll down, you can see related cases right away. You don't have to do a separate search for cases. You find them right there. Okay, give me other states. I know I've got I probably have Minnesota students. I seem to have them every time. So I'm going to go to Minnesota. I'm going to do the same thing.
Illinois.
It's slightly different. Okay, Illinois. It's slightly different from state to state as far as the terms that they use. So rules regulating Florida bar is a little different than what Minnesota says, but we're going to, this one goes right to Minnesota rules of professional conduct. Again, not civil procedure, not the ones at the bottom. It's more towards the middle. Below the judicial conduct, Board of Judicial Standards, then it's Minnesota Rules of Professional Conduct. This one looks right, rules on lawyers' professional responsibility, but it's not. This is the rules on how it's handled. And these are the substantive rules, what not to do and what to do. And most states, it's going to be very similar, even with somewhat different numbering than the ABA rules you already saw last week. But the ABA rules are not official. They don't have enforcement authority, and then they don't have the case decision below them for the correct state. And then you notice that it's a little different than Florida, but the same situation. You can go down to case law. And now we'll go to Illinois. Illinois state and federal, local state and federal court rules. And I believe that's under Illinois Supreme Court rules. Okay, here's judicial conduct. That's not it, but usually it's in the same area. Let's see. No, it's not this time, but it says Illinois rules of professional conduct. If it doesn't say judicial, and rules of normally is the correct one, most states. And rule 1.6 confidentiality. Did I do this too fast, folks? Are we okay? No, because we don't get attendance points for the even numbered classes, but hopefully you get things that will, like this, that will help you create your slideshow for the week and help you pass the test, the quiz. Okay. Who has another state? Because if you can find your state in Lexis, you can, it's so easy to find exactly what you need. I believe there's both types of I'll have to look at it. I'll look at it. What other states? We've done 3 states. I did Minnesota, Illinois, Florida, North Carolina. Okay, let's go North Carolina. Can you see it, by the way? Okay. Statutes and legislation again. State and federal court rules. Um, Here's judicial conduct. Revised rules of professional conduct, North Carolina State Bar. Let's see if these are the applicable ones. These look right. Okay, we did four states, and same situation. You've got comments and okay, some case notes here. Um, the PowerPoint is basically trying to the PowerPoint is all about just following the directions as well as you can in the Module 2 written assignment. What the duty of confidentiality means, who and what topics are covered, and ways in which the firm can maintain. So based on the readings and certainly the research that you do in your home state, that's what that is. Okay, and then the quiz is, let's see, multiple choice. Oh, there are true and false. Okay, multiple choice and true false. Okay. Yes, use Lexis. Yeah, what I did was drill down to Lexis to make sure you can get it. You get to it and then you scroll down and you get to case decisions. That's why we use Lexis. Scroll down, pick a state. You can try statutes first, but then get to rules. And then, of course, in unauthorized practice, you're working with statutes, but ABA opinions are only advisory, so I want you to get out of relying so much on ABA, okay? So you have to use at least 5 slides, and when in doubt, use a site in each slide, other than a title slide at the beginning. So there should be at least 3 to 4 sites, duty of confidentiality, topics covered, and ways in which the firm, there should be a site for each of those. And there is a rubric for that. At least 3 on-target primary legal sources. Fix your grammar and spelling, advanced in development, professional, and so on. Advanced explanation of confidentiality and ways to protect it. And I'm not going to talk about UP. I'm not going to talk about this stuff because we already talked about it. And we're kind of out of time, but I'm going to pause and see if I can find another question. Uh, what do you mean? Inside of each slide, yeah. Each slide, not at the end. 3 or 4 slides.
Professor, if we're citing
Never, 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 never at the end.
or at the end of the
I do
sentence
never.
or at the
You
end of
can
the
do it at the
paragraph?
end of a sentence or paragraph. Yes, you can do it at the end of a sentence or paragraph, but never do it at the end of the paper or slideshow. Because I'm trying to get everybody to do normal Blue Book rather than other methods. Yes, it is a first class to some people, but I want everybody to work on the samples that we have in the sample paper and the sample citations I gave. The rules, if you take the rules right out of Lexis, I'm satisfied with how Lexis cites it. Now, if the abbreviations are slightly off from what they are in the Blue Book helps that are provided for you in the paralegal guide, of course, the paralegal guide is more accurate than Lexis, but I won't catch it. Does that make sense? Um, I'll give you an example. In most um, the first one I won't accept because you didn't put states, but do you see where I put it in the chat? I shouldn't put it on the chat because those watching the other version of it can't see it, but let's put it right up here. Um, of these three, um, one of these is probably perfect and one is not perfect, but I'm not going to catch it. Do you see that? This one I won't accept as a correct citation because it doesn't say the state. Can you see what I have on the whiteboard? This one I may criticize and say, no state, not correct. And these have, these are clear and I can find the source. And here's the lazy one. I suppose I could put Minnesota version ABA rule 1.6. I would say not This would be better than nothing, but not full points. Does that make sense? I can't give you full points for the lazy version, but expecting me to go through 30 of these and catch something this subtle, I'm probably not going to do it. Um, whether it's PROF apostrophe L period, or, I'm not going to catch everything. If you do an appellate court brief, you really want to you want to be, before you graduate, I'd like you to be real persnickety about it and double check and triple check everything before it goes out to the Court of Appeals. I think that when we had when I had, we had two sets of proofreaders, we did get this stuff perfect. To the best of my knowledge anyway. Even format, if it was supposed to be a 1-inch margin or a 2-inch margin on top, we did get all of that stuff, but I had help with that, okay? Eventually, you're going to be better than me at some of this, okay? But if I can't tell that you looked at your home state, if I can't tell where the source is that you used, you can't get a full citation points, okay? Um, you will see you already have some grades for module 1, but not all. Some folks, it's going to take me a couple of days to get the written assignments graded and the discussions, but I have until Friday, but I will try to get them done a bit earlier than that. Frankly, if you turned in a paper for module 1, and you use the right readings, you are on the right track already. If you use the readings, if you did it out of memory, you're not on the right track. Or if you didn't do the readings. And I'm not being personal to the person who asked me the question. I'm just saying this to all of you, all of the whole class. If you use the readings and you cited them, you win. You can use, how it will be 5 slides and we have 3 questions or 4. You can elaborate on a couple of the questions. One of the best ways to do slides is not to pack one slide with too many words. The other thing is, um, well, when in doubt, one of the questions, do you have to follow all of the directions? I would say yes to get all the points. You may turn in twice. If you turned in a module 2 early and separate it into 5 slides and turn it in again, because I allow 3 turn-ins. Every time you add quality and do more of the directions, you're adding points to yourself. You're basically creating you're creating a better assignment on your own, and you're gaining points. You say, well, I have 5 slides prepared, or let's say you have 4 slides prepared. You add a slide, you've added points. Then you look over them again and you say, well, I could proofread for the citations, make sure I have a cited source in each slide. I added points. Then I proofread again and I found a slight mistake in the grammar. I just keep adding points. That's the way I want you to think about it. Don't think of starting up here with perfect and then losing. Doesn't happen. Do not do that. Do not start with 100% and then think, well, what have I done to lose points? You have not lost points. Every time you added quality, you added points. You got closer to the directions, you added points. You added a little better writing, a little better grammar spelling, you added points. Okay. I'm fussy about that for good reason. I've talked to other educators, read a lot. That reduction of points thing is a disaster, and I know some teachers talk about that, but it's a bad policy to state that you're going to take off points. I don't take off points. I add on points. I don't even think of mechanics the same way that this pre-done rubric did. For instance, let's say that somebody gives me 7 slides and 5 of them have perfect grammar. That once they've got their mechanics points, they won. I don't take off points for the one slide that didn't have perfect grammar. Does that make sense? Once you get your grammar points, um, you win. You won them. You own them. Okay. Once you have your number of slides correct, adding another slide that I don't think really helps us, uh, that's okay. You've already earned the, once you got 5 legitimate slides, if you add 2 slides that I think are extra and not helpful, you haven't lost any points because you already gained them. You cannot slide back down this hill. Once you climb the hill, you plant your flag up there, you won. Okay. I want you to think about that. Think about what you do in adult education so positively that you love it and it starts to get fun. Until it gets fun, you haven't really conquered. Once you've conquered that hill, this is going to be fun. This is going to be like adult to adult. It isn't the other thing. It isn't the worrying stuff.